of the debates being sponsored by the University of Washington Debate Union. And the function of the debate union has been basically to provide public access, public awareness of pressing policy issues. So last quarter we hosted a debate on Initiative 502 here in Washington State. And it was a way of getting information out to voters, to people interested in the initiative process and that legislation. The goal is to be able to provide events that speak to matters of interest. Now, at the 502 debate, which was actually just in the next room, during that debate, one of the speakers cracked out a big old pot plant right in the middle of the debate, which was illegal at the time, so kind of is. So I'm assuming no one's going to do some old school hacking on the university computers, which would be fine. But this event is just one aspect of debate here at the University of Washington. This is about being able to provide access to the public, and we also offer intramural debate for students interested in engaging and learning more about debate activities, as well as interscholastic debate. Tonight, I want to certainly thank Anjali Bhatt, who's a graduate student in the Comm department here at the University of Washington, and really basically put this on this evening. So thank you to Anjali. I'd also like to thank the Department of Communications, because they certainly helped in getting the room and providing support for this event. Thanks to them. They're not a person, so you don't have to applaud them. And I also want to thank, we've received funding from the Open Society Youth Initiative, which is a Soros Foundation grant, and that's basically what allows us to provide public events and pay people to come and to work and to film and do the rest. That you can't applaud because they provide money, but they're not doing it. So you can skip that. But I'm going to turn it over to your moderator for this evening, Ryan Kalo. Ryan is an assistant professor at the University of Washington School of Law. And before coming here, he was at Stanford and was the director of the Stanford Law School Center for Internet and Society. Since then, he's also, he does a lot of work on policy pertaining to robotics and the internet. He's written and published certainly in law reviews, as well as the New York Times, Wall Street Journal. He's on the board of the Electronic Privacy Information Center, the Electronic Frontier Foundation, the Future of Privacy Forum, as well as a number of other organizations. Before going to law school, he clerked for the 6th Circuit Court of Appeals. So I'm going to turn it over to Ryan, who will introduce our speakers this evening. Thank you.
Thanks very much. Does everybody hear me okay? So, thanks, Matt, and thanks, Anjali, very much for inviting me to this event. Matt has somewhat oversold me in a couple different ways. So I was a director at the Stanford Center for Internet and Society, not the director. Actually, the director is an amazing scholar named Barbara Van Shevik, who I commend her work to you quite profoundly. She's a really wonderful faculty there and writes about the intersection of architecture and public policy. I think the other thing too is that I'm actually not on the board of the Electronic Frontier Foundation so much as on the advisory board of Electronic Frontier Foundation. So I'm sort of like the junior varsity version of the introduction that you got. That was varsity. I feel like maybe you
never reject a promotion.
No, I know. I just feel like, man, if you were going to go there, like, why not say that I clerked in the Supreme Court of the United States as opposed to the 6th Circuit, which is merely an appellate court and not quite as high. All right, so, but no, I'm just kidding. Thank you very much for the introduction. I really appreciate it. But the real treat here today, of course, is your panelists, Marcia Hoffman and Brian Rowe. And for me, this is actually great because it's an old friend and a new friend, right? So I've known Marcia for years, and she is a senior staff attorney at the Electronic Frontier Foundation. Can we get a quick round of applause for the The work that they do is so significant and so meaningful, and we really appreciate it. And she's worked on a number of different issues. I think she started off early on working on FOIA, but has transitioned to civil liberties of various kinds. Prior to that, I know that Marcia spent some time at the Electronic Privacy Information Center as well, another wonderful organization. I actually recommend that you follow Marcia on Twitter because her tweets are nothing short of fascinating. And if you do, remember that it's Hoffman, 1 F and 2 N's. Common misconception, but yeah, so Marcia Hoffman on Twitter. And I'm really excited to hear from her. and to see her, actually. And so Brian Rowe is a new friend, and he has actually been teaching for us at the University of Washington. He's been teaching at Seattle University. He is a founder of Freedom for IP. Basically, he has been involved in a number of extremely important nonprofit projects that you well know, like Public Knowledge, like Creative Commons, and so forth. And is just a real community and national leader on some of the issues of open access, and et cetera. I want to ask you guys, everybody here know who Aaron Swartz is, correct? I mean, I assume you wouldn't be here if you didn't. Did anybody know Aaron personally, like have a close relationship with Aaron? Okay, I just wanted to say, you know, if anyone did, I'm sorry for your loss. I actually did not know Aaron at all. People I respect and know well knew Aaron. And I just wanted to say that because I'm going to be doing a little bit of moderating and pushing back a little bit against the panelists, and I just don't want to be regarded in any way as flippant. I'm talking about the issues and not about the loss of Aaron, who was a great resource and an inspiration to a lot of people. Okay, so I think that with that, I'm going to turn it over to Marcia, who's going to be this first speaker tonight, and so welcome, Marcia.
All right, that should do it. Okay, great. Can everybody hear me all right? Excellent. My name is Marcia Hoffman. I'm a senior staff attorney at the Electronic Frontier Foundation. How many of you are familiar with my organization, EFF? Okay, great. Some of you are. For those of you who are not, my organization is a nonprofit. We're based in San Francisco. And basically, we work to protect rights on the internet. Sometimes I say as a shorthand, we're sort of like a techno ACLU, but the ACLU doesn't like that very much. Hopefully that gives you the idea, though. So we're here tonight to talk about Aaron Swartz, and we're going to talk about his story from a couple of different angles. I'm going to talk about it primarily from the perspective of one of the criminal laws that he was prosecuted under, which is called the Computer Fraud and Abuse Act. And so my goal, first of all, is to talk a little bit about what we know about the prosecution and, before that, the investigation into his behavior. There are some things that you know we've seen in the indictments. There are some things we've seen in the press. There are some things we're probably never going to know about this situation. But let's just do a quick review of the facts as we know them, just to make sure we're all on the same page. Then I'm going to talk about how Aaron's particular situation highlights some of what I think are some very serious problems with one of the laws that he was prosecuted under. The Computer Fraud and Abuse Act is basically the federal anti-hacking law, and people have been critical of it for a very long time. And Aaron's particular situation, I think, has been something of a lightning rod for those who are thinking that this is a law that could be improved. And as a result, there are now a number of proposals that are floating around about how we might make this law better. And so I'm going to do a quick summary of some of the ideas that people are throwing out there right now for amending this law. And I got to tell you, this is a situation, this is a process that's very much happening. It's actually very exciting to be part of and to watch unfold because you know, Congress and major policymakers are thinking very actively about how we might make the law better. And so, as I'm going to explain, there are some very difficult things to navigate, but you know, you all, you know, if you find this interesting, you should be thinking about this too, because it's a tricky question, and I think that there are various ways that we could go, and I'm very curious to hear what you all think about the best approaches for fixing the problems that we know about. Okay, so what do we know about Aaron Swartz and what happened in his case? So Aaron was a very young, very bright, very visionary person, very, very smart. He was a programmer. He was somebody who cared about social justice. He was an activist. He was a person who was working in many ways to make the world a better place. And a lot of people really respected him and really loved him, as we all know, because of the outpouring of grief after his passing. So the events leading up to his arrest are things that we know because some people have talked about them in the press. And we certainly know the government's perspective because the government ultimately indicted him. And the case never went to trial. And so there was never a time when the facts really came out. But we certainly can know what the government thought happened and what the government's case against him was. And basically, this is what the government says happened. They say that Aaron came to the MIT campus. Now, he was not a student at MIT, just a guy. He actually was a fellow at Harvard, but he had no formal affiliation with MIT at all. One thing that is not in the government's indictment, but something that I think is important, is that MIT has a cultural history of being very open. And in fact, their computer network is open to anybody who wants to come use it. And so Aaron went to MIT. He began to use MIT's network to download academic articles from a service called JSTOR. And JSTOR is basically a publisher and a distributor of academic articles, academic scholarship. And MIT had an arrangement with JSTOR, as do many universities, that allowed users of MIT's network to access articles in the JSTOR collection. And what the government claims is that JSTOR had certain terms by which individuals were allowed to access articles. And MIT apparently had certain guidelines or rules for the use of its network by individuals. And if Aaron were to go and download these articles one at a time, this would not have been an issue. But what he did was he wrote a script that enabled him to download these articles very quickly. And so even under the facts of the indictment as presented by the government, there's never been a dispute that he was allowed to download the information that he was downloading. The real issue was the way that he was doing it, all right? So basically the problem was he was downloading this stuff faster than he was supposed to. JSTOR noticed this, had a bit of an issue with it. MIT noticed it, had a bit of an issue with it. MIT apparently took some steps to try to block him from the network, block him from gaining access to the network. Among other things, they imposed an IP block to basically block the address that he was accessing the system from. He took steps to get around that block. That at some point, they identified the MAC address associated with the laptop he was using, and he took steps to change that MAC address when they took steps to basically block his computer. In the meantime, JSTOR was not enjoying the bulk download and actually blocked a whole block of IP addresses associated with MIT. And so MIT was put in this situation where a number of its users were not able to access JSTOR. Finally, after some days of this, what is described by the government as a cat and mouse game, Aaron went into a closet and he wired a laptop directly into an MIT computer, and he hid the laptop under a box. And he continued to download these articles. And there was some dispute about whether or not this closet was locked. I've heard some people describe it as locked. I think the government would say it was locked. Other people say that it was not locked. But at any rate, he went into this closet, he wires directly in, he's downloading these articles. And there is a surveillance camera in the closet, and they're able to capture him on video. And at some point, the Secret Service gets involved in this whole situation, and they arrest him. And he was ultimately indicted several months later in, I believe, July 2011. 2012. Anyway, he was indicted on several criminal charges. The first was wire fraud, and then there were 3 counts under the Computer Fraud and Abuse Act, which is what we're going to talk a lot about tonight. And as I'll explain in a bit more detail, basically that law kind of broadly says that you're not supposed to gain unauthorized access to a computer, all right? Over time, the case kind of played out, and at some point he was indicted again on additional charges. This time 13 charges, 2 wire fraud and 11 Computer Fraud and Abuse Act charges. When he was indicted the first time on the 4 counts, the Department of Justice issued a press release saying that he was looking at 35 years in prison for having done what he did. And you know, in some of the public discussion of this matter, I've heard some people say, well, in reality, he was never really looking at 35 years, because that's not how federal sentencing works, and it just never would have gone that way. But I think it's worth noting that that is a number that the Department of Justice actually put out there. That was their number. When he was indicted again with the superseding indictment, and he was looking at now 13 criminal charges, you know, I think there's a lot of debate over how much time he was facing, but I think we can say it was a whole lot more than 35 years in prison at that point. And of course, I'm going to be talking a lot about the Computer Fraud and Abuse Act, but the wire fraud law that was used to indict him is also very serious criminal law. And under that particular law, you know, for the charges made against him there, he was looking at you know, very significant criminal penalties, even worse, frankly, than the CFAA charges. So, as we all know, the sad end to this story is that in January, just 3 months out from his trial, he committed suicide. And it's sparked a lot of discussion about a lot of things, many things that, you know, maybe we'll talk about tonight, and maybe things that we won't talk about tonight. I mean, for one thing, there's a lot of discussion about the criminal justice system and whether there are systematic problems that let prosecutors put people in a position where they feel so hopeless, and whether that's really fair, and whether we ought to be treating criminal defendants that way. What I'm going to focus on tonight is the Computer Fraud and Abuse Act, because it's something that I've been thinking about for years already. And to me, when I saw what happened, it just really highlighted some of the problems with that particular law. And let me tell you what those problems are. So, okay, the Computer Fraud and Abuse Act. Now, how many of you have seen the movie War Games? Oh, that's excellent. Some of you are young enough, I thought there was no way. So, War Games, as we all know, is this awesome movie that stars a young and just adorable Matthew Broderick. And, you know, he's like this high school hacker kid, and he ends up basically dialing into this government computer, and he thinks he's playing a game, but in fact he basically he almost starts World War III. And this was a very popular movie at the time. It came out in 1983. Congress freaked out. And the next year they passed the Computer Fraud and Abuse Act. And basically they said, if you do what Matthew Broderick does, like, that is so illegal. That's basically what the law said in the beginning. It basically said that you're not supposed to gain unauthorized access to government computers and to financial institution computers. And over the years, this law got amended several times, and it just got bigger and bigger and bigger and bigger. And it's gotten to the point now where it's just this huge mess. Frankly, nobody really knows what's criminal under this law anymore. This is the provision that is the most broad, and I would say is the most problematic. And this is one of the provisions of the law under which Aaron was indicted. And what this part of it says is, it's illegal to intentionally access a computer without authorization or in excess of authorization, and thereby obtain information from any protected computer. We refer to this as 18 U.S.C. 1030 A2C, and I may make some references later tonight to A2. This is the one I'm talking about, the super broad one. And the real crux of the issue here is that nobody really knows what these words mean. And that's a problem. And the reason why that's a problem is because the courts have interpreted the concept of obtaining information very broadly. So if you just view information, you don't even have to take it away. You just are in a position to view it. That counts as obtaining information. Basically, any computer counts as a protected computer, and that's this legal term of art that's very specific to this law. Basically, any computer that is used in or affects interstate commerce in any way, interstate commerce or communication, or foreign commerce or communication, counts as a protected computer. So it actually is broad enough, it doesn't even have to be connected to the internet. It's virtually any computer you can think of. There are some teeny little limits because the law also defines a computer, and there are some very small limitations there. Basically, a computer is, now remember, this is like from 1984, okay? And this was a law that was written by people who don't know much about computers. So for purposes of this law, a computer is an electronic, magnetic, optical, electrochemical, or other high-speed data processing device performing logical, arithmetic, or storage functions, and includes any data storage facility or communications facility directly related to or operating in conjunction with such device. But such term does not include an automated typewriter or typesetter, or a portable handheld calculator, or a similar device. What does that mean? I have no idea what that means. But anyway, your calculator, you're totally cool. You can hack that, and no problem. No worries about that. So basically, the thing is, the major limiting principle for this section is authorization. But authorization is actually not defined. The major thing that we ask when we say, does somebody have authorization, is whether they accessed a computer without this authorization. And this is something that's just not apparent anywhere in the law. So we can make some guesses. Some courts have been in a position to make some guesses. What do we think, accessing something without authorization would mean? Does that mean bypassing some kind of an access barrier, some kind of a technological access barrier, like, maybe brute forcing a password? Probably that counts as access without authorization. If, there's a password control, you don't have the password and you figure out a way to get around it. That's probably access without authorization. But what about a situation where somebody violates a policy that basically says you're not allowed to access this computer for certain reasons? This has been something that's been a subject of great debate, and we'll come back to this. And then another question is, what about if you're, like in Aaron's situation, accessing information that actually you're allowed to access, but you're doing it in an unanticipated or a novel way, a way that maybe somebody doesn't like? And that's another interesting question that I think certainly never was resolved in Aaron's situation. So the question that I had up there, number 2, the question of whether you violate some sort of a policy or some sort of a contract, has been an issue of great discussion in the CFAA realm in the past few years. There is this case, the one in the middle, United States versus Drew, that's really been, I would say, the most striking example. I'll bet you a lot of you heard about this case in the news. Basically what happened is there was a woman, she had a teenage daughter, and the daughter had a friend, and the daughter and the friend had some kind of a falling out. And the mother of the daughter decided to create this fake MySpace profile where she posed as this cute young teenage boy. And she basically reached out through this profile to her daughter's friend and basically said, oh, you're really cute, we should be friends, whatever. And so the mother, through the fake profile, was flirting with this girl, and the girl developed a crush on this boy, and then she basically turned against the girl. And the girl became very sad and distraught and ended up killing herself. And it was a terrible situation. I think everybody who read about this just thought, wow, that was a lousy, awful thing to do. And there were prosecutors who were looking at this, and they were trying to figure out whether it was criminal. And this woman lived in Missouri, and the prosecutors in Missouri looked at this, and they basically said, there's nothing we can really, do with this. I mean, this could have been something that, maybe she could be sued over, but that's not the same as a criminal thing where you can go to jail. But there was this one super creative prosecutor in California, where MySpace is located, and that prosecutor said, we can make this a CFAA violation, and this is how we do it. MySpace has terms of use. Do you guys know what terms of use is? Who knows what this is? Okay. So this is, virtually every web page you visit, there's a little link at the bottom that says terms of use or terms of service. And you click on it, and it's this huge, long thing, bunch of fine print that some lawyer wrote. And you probably agreed to it before you ever even read it. And it says whatever the lawyers want it to say. And it's basically like, you can't use the service this way, you can't use the service this way. If you do that, we can terminate your account, whatever. So MySpace's terms of service said, among other things, you're not allowed to put fake information on your profile. And so what the prosecutor argued was that when this woman created that fake MySpace profile, she violated the terms of use, and that made her access to the service unauthorized. And that meant that she violated the Computer Fraud and Abuse Act, and she was charged with a felony for that. And felony is a pretty serious thing. You're going to prison for more than a year, perhaps more, and you can lose certain important civil rights, like your right to vote, and you can have a hard time getting a job after that, among other things. And so it's kind of a big deal. And she actually was convicted by a jury for that. And then the judge in charge of the case said, you know what, we can't have this be a CFAA violation. And the reason why that is because basically what it would mean is that anybody who writes a contract is basically going to be in a position to decide unilaterally what a crime is. And so whoever's writing the terms of service, they just get to decide what violates the terms of service, just willy-nilly. And if you violate that, you could go to prison for it. And you could be in a position where you don't even know what's illegal. And this person could change those terms at any time. You could visit the service one day and you're fine, and then the next day you've committed a crime and you didn't even know that the terms changed. And so it's very important when we're talking about criminal laws that people actually be on notice what is actually a crime. And if we interpret the Computer Fraud and Abuse Act to include violations of terms of use and similar contracts, then that's going to be really problematic because people just aren't going to know. And so that, I think, was a good result. I think that was the proper result in that case. We've seen other similar cases where people have tried to argue that violations of terms of use or contracts are CFAA violations. The one at the top there, Facebook versus Power Ventures, that was a situation where Facebook basically sued a competitor for accessing information on Facebook in a way that Facebook didn't like, even though the users of Facebook that the competitor was kind of catering to had given the competitor permission to access their accounts. And again, that didn't work. United States versus Nozzle is a case in the Ninth Circuit Court of Appeals that came out just this past year that basically reached the same result. Violating a private agreement is not a violation of the CFAA. Here's something that's very important. The top one there, Facebook versus Power Ventures, you can see that is a dispute between two private parties, right? That's a civil dispute. The last two are, it's the government going after somebody. That's a criminal situation. And this is what is really difficult about the Computer Fraud and Abuse Act, one of the very difficult things. It is a law that is both civil and criminal, meaning that if you break it, somebody could sue you for money damages, but also the government can go after you for the same thing. And it might make sense in certain cases that somebody who accesses somebody else's service in a way that that person doesn't like might have to pay damages. But does that necessarily mean that that person should go to jail, right? And so this is one of the big tensions about the CFAA. We'll talk about that a little bit more later. So another couple of things to keep in mind, especially when we're talking about Aaron Swartz, is that the provision that I've been talking about, the one that is the most subject to abuse, is not the only CFAA provision that he was charged with. He was also charged with this one here, 1030A, which says that accessing a computer without authorization or in excess of authorization in furtherance of a fraud is illegal. And this guy here, 1030A5, which says that intentionally causing damage to a computer without authorization or accessing a computer without authorization and causing damage is illegal. And again, this could be both civil and criminal. And these, you'll notice, contain this similar language, right? Without authorization, without authorization. We see this again and again. And while there are technically 7 different things that you can do to violate the CFAA, they almost all include somehow accessing somebody else's computer computers without authorization or in excess of authorization. And so in Aaron's case, this was a really important question, because if he had not accessed those computers, or rather, if he had authorization to access the computers at issue, then that knocks out all of these things, right? And so there are all sorts of CFAA provisions that just wouldn't have applied. Okay, so another problem with the CFAA penalties. So as I mentioned, this law is difficult because it's both civil and criminal. Just looking at it from a criminal perspective, basic unauthorized access for a first-time offense is generally a misdemeanor, which is a lesser level of punishment. Basically, that means that you could go to jail for up to a year. But the law provides for broad felony punishments in a lot of circumstances, even for first-time offenses. So even for a first-time offense, you could be looking at a felony if the act is committed with intent to profit, if it's in furtherance of a fraud, if the person causes up to $5,000 in damage, or the information obtained is worth more than $5,000. And in Aaron's situation, even though he'd never been charged with the CFAA before, charged with this CFAA violation before, he was looking at felonies because of our stars there. Basically, the government's argument was that these academic articles that he was obtaining were worth more than $5,000, and therefore these were felonies. And he may not have done this before, but they were in a position to throw the book at him. Okay, so these are some of the problems with the CFAA. And I think a lot of people, I think that many people are struck by Aaron's story for a lot of different reasons. I think that some people feel that his goals in downloading the information were worthy goals, and that he should not have been punished for any of it. I think some people feel like maybe what he did was not that great, but it certainly wasn't worth decades in prison, right? And so I feel like the reform ideas have kind of gone along a couple of different axes here. So there's this professor named Oren Kerr, who's one of the foremost computer crime professors in the country. He teaches at GW Law. And he has several ideas for how to basically fix some of the problems that we saw, I think kind of underscored, not just in Aaron Swartz's case, but in some of the situations we saw before, like the Lori Drew case, which, as far as overreaching CFAA prosecutions go, I think that one is about as bad as it gets. So his first idea is that we need to define the concept of the term without authorization. And while the law doesn't currently say what is without authorization, it does define exceeding authorized access. But basically what that means is obtaining something or gaining access to a computer without authorization and getting info you're not supposed to get. So it basically relies on without authorization, despite the fact that it's not defined. So basically what he says is we should just actually define what that means and get rid of the exceeding authorized access stuff, because that is the thing that has caused a lot of problems in the cases arguing that violating contracts violate the CFAA. So he says that's one way to fix that problem. The other thing he says is we should raise the felony triggers so that more CFAA violations are misdemeanors and fewer are felonies. And then he also says, because we have so many different CFAA provisions that use this concept of without authorization, basically a bunch of them are just duplicative. And so to the extent that we have that problem, we should just strike those guys out. Okay.
Not that on.
He also says that we basically should just make it so that this is just a criminal law and not a civil law, because he feels like the civil cases are the ones that actually open the door to courts being more likely to find that violating some kind of a contract violates the CFAA. And he feels like if it was strictly a criminal law, I think the courts would be more serious about interpreting it more narrowly. And so that's what he thinks we ought to do. My organization has put out some ideas as well. We generally think that his suggestions are good ones, and that also it's really important for us to think about how to create breathing room for situations where people have authorization to access information, but they do it in a way that's maybe unanticipated. And we think that this is important because people do these technical workarounds all the time in order to protect privacy and anonymity, to perform security research, and also to create awesome add-on innovation to things that already exist. And if we don't create that kind of breathing room, we're going to miss out on a whole lot of very socially desirable things. We also think it's really important to fix the penalty scheme so that it feels more like the penalties actually match the offenses. And we have several ideas about how to do this, but for one thing, we think it's important to make more first-time offenses misdemeanors, and to make sure that if you're going to ratchet up something into a felony, that there be really good reasons why that happens, like somebody's doing something for commercial profit and they're getting information that's very valuable, that kind of thing. There's also a proposal floating around called Aaron's Law that Representative Zoe Lofgren has introduced. Rather, not introduced, she's basically proposed it for public comment, but it's not actually pending legislation yet. And she's thrown out 2 versions of it. She's put them both up on Reddit and solicited feedback and comments. The version that's there right now basically would do 2 things. It would clarify that violating a contract doesn't violate the CFAA or the wire fraud law, which is the other law that Aaron was charged under. And it would also take steps to try to make sure that certain efforts that people might take to protect their privacy don't violate the CFAA or wire fraud law. And basically, she's saying either of these things or these things in combination with nothing more shouldn't be unauthorized access. So that's basically the state of things, and I look forward to hearing your thoughts and reactions, and thank you for your time.
Thanks so much, Marcia. So just to give you guys a little roadmap, we're going to hear next from Brian, and then I'm going to take moderator's privilege and ask a couple of my questions, and then I'm going to open it up to all of your questions. And there is a microphone down here that I think that Matt's going to end up being in charge of, and so that's how you ask questions. So now turning it over to Brian.
As you heard, my name is Brian Rowe. I teach here at the University of Washington Information School, Law, Ethics, Intellectual Property. I also teach privacy law over at University of Washington. I wanted to say thank you to the Communication Department. I'm very glad to be here. Thank you for the effort in organizing this very important topic. Also, seeing that it's a debate, it warms my heart in that parliamentary debate, probably the type of debate with the least amount of evidence, but the most amount of interaction from the audience was definitely my favorite. So whether you agree or disagree, I really look forward to hearing from you throughout this. So let's jump in here. I'm not really a typical professor in that I don't take a neutral stand on anything. I'm a huge fan of Howard Zinn. And I believe that when it comes to policy around things like what we call intellectual property, which is probably extremely poorly named, that we are at a point where we get to decide what the policy is for the future. Aaron Swartz also had some very strong ideas that I want to talk about today with regards to that policy. And I think one of the most important things we can look at is some of the things that he has said here. Information is power, but like all power, there are those who want to keep it for themselves. This was from his Guerrilla Open Access Manifesto, which he published back in 2007-2008. But before we fully jump in, I need to let you know about my background a little bit also so that you can see where I'm coming from. Right out of law school, I would have called this a disclaimer portion, but I'm actually pretty proud of this, so I don't really want to call it disclaimers. I worked out at Creative Commons while I was in law school, working on their open licensing, and then directly after law school, I worked out at Public Knowledge on a Google Public Policy Fellowship. wonderful place to be trying to do user rights lobbying at Congress. It's a very odd form of lobbying because we don't actually carry any money around with us. We went and tried to convince people over what they should do with regards to what is best for end users. I also have been strongly involved with freeculture.org, Students for Free Culture. As a student, I helped with the process of writing the Constitution there, and am now a faculty advisor to that group. I hope that you're able to put together a group like that here in Seattle. There are also some other organizations that I strongly respect their particular perspectives, although I don't necessarily see eye to eye with them. I have been and am still a member of the Free Software Foundation. I do a lot of things with regards to disability rights. And it's why I view several of these issues that we're dealing with as basic human rights, not just policy decisions. And I've also helped a little bit with the formation in Washington State of the Washington State Pirate Party, and I'm very familiar with their perspectives, although we diverge from time to time. The issue here, though, is a bigger issue than this, just the particular acts that we're looking at. There's a fundamental difference between bits, ones and zeros, information, knowledge, data, and apples. And somehow, we've, from a policy perspective, decided that we should use property law and restricting information and apply it to ones and zeros. One of the major differences is when I eat an apple, you also cannot eat it. It's fundamentally rivalrous. The value of that apple falls, unless you really want an apple core, which I've helped you get closer to. With regards to a piece of information, though, as several different artists have figured out recently, the more people that listen to it, the more people that have access to it, the more valuable it is. Lady Gaga had to argue with Amazon to distribute her album at $1. Macklemore from Seattle put out most of his music on YouTube well before radio stations would even listen to it. And the most interesting of these is 9 Inch Nails, who after he had went to a concert, Trent Reznor threw out thumb drives into the audience, telling people, here's my new song, go home, share it, create some hype around this. His record label started to send cease and desist letters to the individuals who were sharing it, who were doing the marketing that he wanted. He dropped his label, and when Ghost Album 1 through 4 came out, he put it up online, available to download, on BitTorrent, under an open license also, and he made $2.1 million in the first 2 weeks. But the more impressive thing was that after a year on Amazon, it was the #1 sold album on Amazon, even though it was freely available on open networks. So we have a situation that is also occurring here in the ivory tower, in which we are applying these same rivalrous rules and only allowing those individuals in the elite academic institutions to access information. And this causes us problems both inside and outside of academic institutions. Inside academic institutions, we get these silos, to where I work in law, and I also work in technology, and it's amazing to me how many times I read about similar ideas that have been discovered independently. Well, they probably were discovered independently because nobody reads the articles from any of these other silos. But the worst part is when you're outside of these silos, everything looks a lot more like Hoth. It's more like a giant desert where you have no access to any of the information that is available. So we've taken this idea of property, applied it to information, and then wonder why nobody cares about the articles that we write, because they don't have access to read them. The other thing that we've done is we've created a situation in which the norms, the things that we do on a day-to-day basis, have been criminalized and given huge civil penalties. Myself, as a kid, I used to create mixtapes. This was my way of getting over being shy when I wanted to date someone. This was also the way to express to my friends the things that I listened to. Now this mixtape that I created, if I was to create that today under the Copyright Act, I would be liable for $150,000 in statutory damages times the 10 songs that I put on there, or $1.5 million in damages. What we've created is a situation that whether you're forwarding emails, or remixing things, or sharing things, whether it's academic or whether it's cultural, everything potentially has these penalties. And when all the actions we're doing are illegal, the government then has the option to pick and choose the individuals, such as in this case of Aaron Swartz has recently come out in congressional hearings, that they did not like the opinions that were put forward in the Guerrilla Open Access Manifesto, and then choose to enforce the law against him, even though all of us are infringing upon the current laws and doing things that are illegal. The other thing that we're doing is, because of our fear of bits flying around freely, we're putting locks into our electronic devices that allow them to remove the content that we have and also look at what we're doing with our devices. So we're putting in steps that violate our privacy and our own personal rights to these things because we're trying to stretch that analogy of property onto bits. But it's really easy to come up with the problems in this situation. And what I'd like to focus a little bit on also is the solutions. As an educator, I've signed on to the Cape Town Open Access Declaration, which really has two prongs to it, although somehow they divided it into three. Those two prongs being, one is as an educator to try to use open access resources. All the syllabuses that I put up online, everything that I can possibly put is freely available for download. You don't need a textbook for it. But also, is to try to get institutions to sign on to those type of things. Because an individual professor really has very little power in this situation. It's departments, heads, and schools that need to adopt these types of policies. I was really pushed in this direction after seeing a contest in 2007 when I was still in law school by the National Academy of Recording Arts and Sciences, or the Grammy Foundation, that they're asking for new ideas on how to deal with intellectual property. But directly in the contest was you signing over all your rights to the Grammy Foundation just to enter this law review article contest. And this law review was published, unfortunately, in a journal that had signed on to an open access pledge. So it's more than just putting together a pledge, it's taking action beyond that. We have to support the individual artists, creators, and authors. The individuals here are Margaret Chung and Girl Talk, who it's odd to have them both on the same slide. One being a remix artist and the other being a social justice professor, one of my mentors. But both of them have created artwork or works of authorship that they then make available freely for individuals to use and access. For each of these communities, there's different norms of how to put forward and help those individuals. But new economic models are coming forward to support artists like Kickstarter. And with the things that I put into my syllabus, I try to direct them to a way that they can download it like SSRN so that an individual knows if their items are being read. It also keeps track of how many other people cite them. So it creates this economy of reputation, which is what really matters to us. I mean, I write things so hopefully people read them and maybe even act upon them. The other thing that I would like to discuss today here is a little more controversial, and it's the idea of civil disobedience, which I've really struggled with a lot myself. The Open Access Guerrilla Manifesto really says at the end, we need to take information wherever it is stored, make our copies, and share them with the world. We need to download scientific journals and upload them to file sharing networks. We need to fight for guerrilla open access. Obviously, the way that the laws are, that opens you up to large areas of liability. But the things that I do on a day-to-day basis are somewhat in line with this. I share, listen to, and distribute Girl Talk's music, which has been removed from iTunes because of their worry about liability. And one of the few pieces of academic materials in my current syllabuses that are locked down is the theory of justice from John Rawls, which is rather ironic as I teach the veil of ignorance there, which is a policy deciding piece, where you try to come up with a policy that protects those who are worse off in society. And it's one of the few pieces that I can't get copyright free. So I have distributed that to students who don't necessarily have a copy of their own. But I would like you to also take time and engage in this conversation. Myself and a few recent law graduates and techies here in the Seattle area have put together a group called Digital Rights Northwest to discuss these policy issues and bring them up on a state basis. I also put all of my own work. out there under a Creative Commons by license, although if you remix it and don't give me credit, I'm never going to sue you. So I should just put it under public domain. Thank you.
Wow, thanks so much to you both, to Brian and to Marcia for that great discussion about the topics and about what happened to Aaron Swartz and what some of the problems and context are around that. And again, I want to be clear that I'm going to be putting on a moderator hat here and pushing back a little bit, but I don't mean it to be disrespectful to anyone. And the first thing I'm going to say is, remember I said that Matt had significantly oversold me in his introduction, right? And I just want to make sure that we're not overselling the issue a little bit and that we're being really careful, right? So Marcia, for instance, starting with you, doesn't the CFAA require, right, in almost every instance, a showing of some kind of damage that you've done? In other words, just so you go on a website and you happen to pretend that you're someone else. People have talked about the CFAA as making it unlawful to violate the terms of service that you read every day. Isn't that a little bit of an overstatement right there?
Nope.
No? So tell me more, though. So you mentioned that there were certain provisions that require damages, but you're saying that there's a possibility of committing a misdemeanor without any evidence of damages.
So basically, this is how this works. The provision that I mentioned that I find the most problematic and that's been most at issue in the courts requires only that you intentionally access a computer without authorization or in excess of authorization and obtain information. Those are the elements. It doesn't require damage. If you are going to sue somebody for having violated that provision, there is a basic threshold that says that you must have basically sustained $5,000 in damage. And I'm going to come back to that in a minute. But for a criminal prosecution, that's not necessary. And something that's important to also know about the CFAA is that the term damage is something that is defined in the statute. And basically, it's an extremely low threshold. So that $5,000 can include, for example, the person time that an IT guy puts into kind of investigating what happened and kind of taking care of the situation. And $5,000 is an amount of damage that could be, I think, racked up pretty quickly when you look at it that broadly.
Right. I mean, and plus there's the idea that if you do this more than once, say you're engaged in what Brian is calling civil disobedience, that ratchets it up pretty quickly too. Can you talk about that? What happens if you do this kind of thing twice because, like Thoreau, you believe you shouldn't be paying a poll tax, right?
Right. I mean, as it's written right now, basically repeat offenders are subject to felony violations pretty quickly. There are actually very few offenses under the CFAA that count as misdemeanors. As I mentioned, generally, if you do something and it's the first time you've done it and you don't cause any damage and you don't obtain any information that has any value whatsoever, you might actually get a misdemeanor penalty there, but it's very easy to rack up the penalties pretty quickly. And in Aaron's situation, the reason why he was looking at felonies was because the government said that the value of the academic articles that he was downloading was more than $5,000. I'm not sure that I ever saw an actual number put on what the government thought that information was worth, but we're not talking about songs here. We're not talking about information that I think normally is considered to be very high value, but given the volume of the information that he downloaded, that was a problem there. And then also I think that probably the amount of time and resources that MIT's IT department and probably JSTOR's IT department put into investigating the situation would meet this $5,000 threshold, which in a criminal situation is enough to knock it up to a felony.
Okay, okay, I appreciate that. That's actually a very satisfying answer, Marcia, I have to say. So, but Brian, let me go to you. By the way, I saw the Linux logo, right? The little penguin. I was in China recently, and the really big internet company there has an almost identical logo that's just a Linux penguin, right, with wearing a scarf. So speaking of intellectual property issues, it seems like an awful bad trademark issue, but I'm not an expert. So what about you? Are you overstating the case a little bit, Brian? I mean, you talked about how, and I'm paraphrasing, of course, that you'd be subject to thousands, maybe millions of dollars in damages for quote unquote remixing. But do we not have a right to fair use in this country? Can't we do some amount of remixing and tinkering and so forth under the protection of fair use and copyright? I mean, even your own slides contained book covers and the image of the Kindle, and I don't know. I mean, maybe that's what the lights are about, but I don't see a SWAT team here today. So I'm just wondering. Can you talk a little bit about, are there not adequate safeguards in place that tend to undermine your case that it's a problem?
Well, there are some exemptions to the law put forward, such as fair use, definitely. Although unfortunately they're extremely weak. Fair use is a defense that comes up very late in the process. And if you lose, you can be out your opponent's lawyer's fees. So if someone sends you a letter asking for $3,000 or $4,000 in order to use something that they have, even if you are clearly sure that it is fair use, it has to go to a judge, and then a judge who may not know very much about art becomes the arbiter, or a jury in some cases, depending on how the judge wants to look at it. And then you could be on the hook for hundreds of thousands of dollars if you lose that fair use defense. Fair use is not something as strong as anti-SLAPP is here in Washington State, where you can shut down the process extremely early, get a determination, stop discovery, and end things right away. It is very weak, unfortunately. It's something that I stand behind because it should be the codification of the First Amendment in the Copyright Act, and it should give us the rights that are needed for our free speech, but it doesn't stop things like takedowns from happening for political speech on YouTube, which is clearly remixed and time sensitive. We have situations where copyright takedowns and threat letters are stopping legitimate, useful, both creative, transformational forms of speech and political speech that individuals don't like.
And people are pretty clear what we mean by fair use and copyright, right? I mean, that's something that I'm seeing a lot of nodding here. Okay, thank you, Brian. So let me try a different tack here then and ask about what a person might like about the Computer Fraud and Abuse Act. So, for instance, it seems like there's a saying that you hear a lot in, at least among law professors like Brian and I, where they talk about how bad facts make bad law, right? And so when you have some person who was just engaged in, at most, a mild form of civil disobedience, and the overzealous government prosecutes him to the point that he feels that it complicates probably existing depression and it causes a suicide. That's extremely bad facts for the government, we have to agree. But what about, for instance, the small business who's taken advantage of when someone hacks into their computer? What about the domestic violence victim who wants to seek recourse to an ex-boyfriend who is attempting to meddle in her computer and has some kind of computer savvy and feels deeply victim? I mean, is not the CFAA not a tool also for the victim? And can you speak to that at all? Mm-hmm.
No, I think that that's absolutely right. And I don't mean to suggest that I think that there shouldn't be some kind of a law against hacking in a way that really causes damage for a person and is malicious and causes a great deal of harm to somebody. And that certainly happens. That certainly happens. I think the problem that we're trying to deal with here is the fact that it's written in such a way that it can be used quite arbitrarily to go after somebody. And in fact, it can be used to go after somebody for something that isn't even really what the law is meant to target, right? Like the Lori Drew example. The reason why this woman was prosecuted was not because she created a fake MySpace profile. That wasn't the problem. The problem was that she bullied this girl, and this girl committed suicide, and everybody thought that was a terrible thing. But this was the thing that they could get her for. And so that is, I think, just a perfect example of why this law raises such concerns, because it basically makes it so that probably all of us have violated this law, but we haven't done anything else that would draw the attention of prosecutors. But if we did, and they couldn't really get us for that thing, they could get us for this thing. And it's a very heavy club.
Yeah, I hear what you're saying, although I thought I heard you say that you endorse the views of, that your organization endorsed the views of Oren Kerr that we should be possibly getting rid of the entire civil section of this. And so in other words, it's not that, and so even for those core examples of what this thing is getting at, which is hacking into someone for real mischief, it sounds like you want to do away with this civil statutory recourse that the, say, our domestic violence victim can go into a court of law herself. And so, can you respond to that as well?
Absolutely. Basically what Professor Kerr has said, and what we agree with, is that the civil cases are the ones that cause the most problems. And that's because that's where the case law really got this foothold. Where there was some kind of a contract dispute between two people. These cases really originated, weirdly enough, in the employment context. There were situations, this happened several times, where there was an employee at some company who then became a disloyal employee and gained access to information that they were authorized to access in the course of their employment, but then became disloyal and said, I'm going to take that information, I'm going to go start a competing business. And the court said in that context, yeah, you should be able to do that. That's not cool, you can't do that. But then the problem is that that creates a precedent that can be used in criminal cases as well. And so I think that's the problem he's trying to address. And basically what he's suggesting, and I think this is right, I have yet to see a case where this doesn't work. But I feel like to the extent that there are civil cases, all of the concerns that people have are addressable under other laws. Like, for example, if your problem is that somebody violated an employment agreement, that's breach of contract, right? That's not necessarily hacking, or it shouldn't be hacking. Similarly, if you are stealing information from your employer and then taking it to go start a competing business, that's generally going to be theft of trade secrets. If you are, hacking into somebody's computer and stealing social security numbers, that's generally going to be identity theft, right? There are already all sorts of other laws out there that address a lot of the things that we're worried about. And if there is some concern, some worry that isn't addressable by some other civil law, then I think that's worth discussing. And if you guys have examples, I'd be interested to hear. But the concern is that the civil context creates a much broader atmosphere where people can take these legal causes of action and really go after people, and courts are more lenient with them. And because this is a criminal law, we need to be very careful not to let it get too broad. And we need to make sure that we are enforcing this law in a way that's fair in a criminal context, since people can actually go to prison and go to prison for a long time if they violate the law.
Brian, do you have thoughts on this as well?
I definitely think that most of these issues can be dealt with torts or some other type of cause of action. Additionally, I think that it is the wrong way to deal with items such as privacy protection, which is extremely important, and we need to look at privacy protection federally comprehensively. It is great in some states, and it's abysmal in others, but putting it under hacking is the wrong place for it.
Yeah, I tend to agree with you guys. I think I could quibble at the margins about the difference between pursuing something in tort law, where you have to go by common law principles to show damage and so forth, versus pursuing it under statutory. But I get the point. So another question I have is, why isn't this just at base an ethics issue? In other words, there's lots of laws that are written broadly that police are in a position to abuse. I used to investigate allegations of police misconduct in New York City I don't know where you were on that one, Matt, but that's a very interesting fact about me that I didn't hear. I'm just kidding. But I used to investigate allegations of police misconduct, and whenever we would actually see a pattern that would sort of not necessarily be abusive, but sort of smell like abuse, where someone was getting a bunch of disorderly conduct and resisting arrest. It was like this pattern where there was something amorphous like disorderly. Anyway, there's lots and lots of places for the possibility of abusive discretion, and for the most part, we rely on having a culture and having ethical things in place. I mean, wasn't this just and also the Lori Drew case, by the way, just a grotesque display, in a sense, of prosecutorial overreach, and is tinkering with the law necessarily going to get at that? And I'd like to hear from maybe Brian first, and then Marcia, if that works.
Well, I think that it could be interpreted as prosecutorial overreach, but I think from reading the statute, it is clear that some of the actions could have definitely fallen in that category. And what we have is a set of laws that are so far behind the cultural norms that it has criminalized and opened us up to individual civil liability that is larger than the massive student loans that we're seeing people end up with. We're talking hundreds of thousands of dollars for what we do on a day-to-day basis. And when it comes to be that large of a disconnect between the social norms and what the law says, we're going to end up with intermediaries who take advantage of that and use it as a way to basically extort individuals. And I think that's the point at which we have to look at seriously redoing and revisiting those laws for a digital age.
You know, a lot of my public comment on this case has been about the CFAA, and in large part that's because it's something that I've looked at for a long time and I've cared about for a long time. But I think it's absolutely true that if everything in the world was done to fix the CFAA, that would not fix a lot of the problems that contributed to the Aaron Swartz situation and how tragically it turned out. And I think that there are all sorts of other things we ought to be looking at. One of the reasons why I like to kind of focus on the CFAA is because I actually feel like there is some progress that we can make there, and there's some momentum to make that progress. And it feels good to think that there's something that's positive that could come out of this. But there are certainly other things that we ought to be looking at, like, for example, support for people who are suffering with depression. Certainly I think it's worth thinking about the greater criminal justice system and some of the tactics that prosecutors use when they're going after people. I mean, for one thing, the vast majority of criminal defendants never go to trial, and that's because the deck is basically stacked against them, and they're given every incentive to just admit their guilt and not actually go to trial to try to assert their innocence. And some of the tactics that contribute to that result are things like what we saw here, which is not unique to Aaron at all. I think a lot of criminal defendants see this, where they're charged with a relatively few number of things, and then the closer they get to trial, they're not taking a deal, and so the prosecutors will just ratchet up the potential punishment. And I think that that's something that's clearly meant to try to make people not go to trial and encourage them to basically just sort of take their lumps and do it as happily as they can, which obviously is not happily. But the point is, the criminal justice system is not really set up in a way at this point where people have any incentive to go to trial and assert their innocence and try to defend themselves. And I think that's a huge problem. And it's something that's very sobering to think about. And when you think about the amount of work that is going to have to go into fixing a problem like that, it's pretty daunting. And I think it should be done. I think it's going to take longer. It's going to take longer to do than fixing the CFAA. That's for sure.
Well, it's one of the reasons that I see this issue more as a human rights issue than just a single statute issue. We are seeing parallels of the same thing happen with regards to criminal prosecutions and disparate impact dependent on individuals' race or social economic standing. So it goes well beyond just this particular statute.
Absolutely. And this particular person.
Right.
Okay, so I have 100 more questions to which I won't subject you to each of them. I just want to make sure that we have time from this audience to ask questions. And I guess Matt has a microphone, and maybe if you could introduce yourself before you ask your question. But is anybody out there, by the way, I'll ask questions all day, but if you guys, does anybody out there have a question for our panelists? Yep.
You
want to step
you
up?
just come step over here.
Oh yeah, just line up over there, sorry.
I'm loud, don't need a mic, but my name is Kathy Gill and I teach here. Would you all speak to the assumption that that Aaron was going to do something nefarious with the documents as contrasted with perhaps, doing research on patterns and so forth, and the fact that half of the documents were public domain?
Yeah, I mean, it was clear from Aaron's earlier writings that he did intend to share those. A significant portion was what you mentioned was public domain, which means that there's no copyright, there's no restrictions on them. And the act of digitizing those by JSTOR basically put them in this silo that then they used a contract to wrap them in and keep people from. And Aaron definitely saw that we were at a point in our history where those 100, 200, 300 years, and as we look at what Google Books is doing, even 400 or 500 years worth of printed text are making it into a digital medium, we have the opportunity now to choose that these are in the public domain. Is there something we can do to make them available to everyone? When Aaron and JSTOR spoke over the cost of opening that up to everyone, JSTOR valued that material at about $250 million. That's what they would want to make it publicly available to anyone. So they were in a space where there's huge benefit for them keeping it private, even though our salaries have been paid. We created that research to improve the lives of others. And it's depressing to know that people don't get a chance to read those.
I have 2 points in response to your question. The first is, the question of whether he was going to do something nefarious or not. One thing that I think is worth noting is that even the government conceded that it's not as though he was intending to profit or anything. I think they basically felt, based on the Open Access Guerrilla Manifesto, that he was likely to, liberate this information and make it public, and that was the most nefarious possible intent that he might have had. And whether you believe that's nefarious or not, I will leave up to you to decide. Certainly the government felt it was pretty awful.
But it's like arresting you for murder before you kill someone.
Right, he never actually released this stuff. And I think it's also interesting to note that you might think that the most obvious thing to charge him with might be copyright infringement, and he was never charged with that. Even though there are criminal copyright infringement causes of action out there. I think it's interesting that they never tried to make that case, and my suspicion is because they felt like it was probably going to be very difficult for them to make as strong a case as just unauthorized access, right? The other thing I wanted to point out is, I don't know how closely all of you are following this story, but there was an article published just last night by The Atlantic by a woman named Quinn Norton, who is a journalist, and she also was, at one time, Aaron Swartz's girlfriend. And she published a very sobering account of her experience basically getting dragged into this investigation. And she says in that article that she actually doesn't really think that he intended to publish this stuff publicly. She said that he had a history of kind of collecting data sets, and at some point she overheard him telling a reporter that he was gathering this information for some academic research that he himself was doing. And she actually questions that his intent was to publish this stuff and liberate this information. She said that she, her understanding is that the manifesto was actually written by 4 different people. Aaron was one of them, but he wasn't the sole author. And she also noted that he had written it some years ago, and she believed, honestly, that he had kind of moderated some of his views on that count. So just worth noting, and if you're interested, I would read that article because there's a lot of very interesting stuff in there.
Computer science graduate student. Thanks for bringing up that article, by the way. I have to say it was really, really quite powerful. So I have 2 questions. One on the issue
So not really, but I think you've identified something that is a hugely important question because in this day and age, I feel like we carry these devices and they're manufactured by one person and you buy it, or maybe do you license it, and then there's software on there and then you're accessing accounts from it. And I feel like there are all sorts of different people who might have some, let's say equity in the device and who might try to, argue that they are the ones in a position to grant authorization or not. And that particular issue has not really come up squarely, but at least that I'm aware of. But there was a really interesting case a while ago where Sony sued this guy named George Hotz. He basically extracted some encryption keys from the PS3 video game console that made it possible for people to jailbreak the console, to run their own games on it that they had written, or perhaps pirated games. So Sony sued him and some other fellows as well who kind of learned how to extract that information from the PS3. And one of the claims that Sony made was that Hotz and these other people violated the Computer Fraud and Abuse Act. And the reason was that the Sony PlayStation Network has terms of use. And by accessing the machine in a way that Sony didn't like, these guys violated the terms of use. And therefore, their access to their own video game consoles became unauthorized. So basically, they didn't, I think that basically what Sony was trying to suggest was either that these guys didn't own the box, or that Sony was in a position to decide that there'd be no more authorization somehow. And that case settled, and so those arguments never played out, and no judge ever decided who was right. But I thought that was a very interesting sort of harbinger, maybe, of what we might see in the future.
Right, this issue of authorization definitely hits upon a way that companies are trying to control access to what would traditionally be devices or things that would be ours. 50 years ago, I could take my pocket watch, I could take it apart, I could fix it, I could change the winding mechanism. Now with an iPhone, I can't take it apart to change the battery, I can't get into the operating system, I can't do anything. So this really fundamental freedom to tinker with the things that we have is being taken away through laws like this.
My name's Eric. I'm a mobile application developer. Probably met at Info Camp last quarter. So the question is, so you mentioned about a solution on how the law is not up to date and it needs to be more applicable to like today's technology. But then, as like a lot of us know that like technology is constantly changing. Do you think that writing another law, like the solution should be writing it so like we never have to write it again and it's open-ended for the future, or like a constant technology could change it, but obviously in the next 5 years and we have to rewrite it as a constant like rewrite, or like you think that we just should get it right the first time that applies for the rest in the future?
Let me pile onto that too. I think that's a great question, and I was going to add that the CFAA has been amended something like 9 times, I think, at this point. And how do you deal with changing technology in a way that is constant with the principle of fair notice that you identified? And that's a great question.
That's a wonderful question, and frankly, I think that every professional, every legal professional I know, every law professor I know who thinks about technology-related law really struggles with this. And I don't know that there is a right answer and a wrong answer. I think a really great example of this is ECPA, the Electronic Communications Privacy Act, which is a law that was passed in 1986 to try to update wiretapping law to reflect the realities of technology. And it's never been significantly updated since. And so that's the law that applies now, right? And I don't think Congress or anybody else could possibly have foreseen where we would be in terms of the technology that we're dealing with. And there's a big push now to update that law. Whether or not it's going to happen, remains to be seen. But it's a big deal to update a law, right? And this is a question we're really struggling with as we're trying to figure out how to make the CFAA better. Because if we were to say something like, bypassing a password violates the CFAA, that's great, but are we going to be using passwords in 10 years? Are we going to be using biometrics? Are we going to be using something else? You know, and so trying to come up with the right concept has been a real challenge. And if you have good ideas about that, I would love to hear them. I was kind of maybe kicking around an idea of something around credentialing, if you bypass a credential. But, you know, is there going to be some situation in 20 years where it's just not going to make sense that we just can't foresee? But on the other hand, if you try to be very technology neutral about it, does it have any meaning? Are you writing it in such vague terms that nobody even knows what you're talking about? So yeah, it's a huge tension.
I think this is an area where technology can inform law. In law, we tend to look backwards and try to see what has worked in the past and try to stretch that analogy to fit what's new. In technology, we realize that things change and we need an iterative design process and that we're going to screw it up and that we need to fix it when new technology comes forward. In Washington State in 2004, we passed the Access to Justice Technology Principles. And we told the Supreme Court at the time, which is a Supreme Court order that put those forward, that we needed to revisit this because we don't know where the technology is going to be. And that's what we need to put into the law, is that iterative design process, so when new challenges come up, we don't keep prosecuting people under old, out-of-date laws, but we update them.
All right, so we've got just a few moments left, so this will have to be the last question.
Hello, my name is Alex. I'm an econ student at the University of Washington. I want to thank you guys for coming down. It's, I guess it's a little bit appropriate that this is the last question because it's about the future. After the media attention that Aaron's story has gotten since January, what do you think the feasibility is that something like Aaron's Law or the reforms to the CFAA get passed in Congress? And if I could ask a follow-up question, who is standing against those types of reforms?
So I have been amazed by the actual amount of interest in doing something to reform the CFAA. If you had asked me like 2 or 3 days after Aaron's suicide, I would have said, you know, I'm very skeptical. But there has been some sustained interest in Congress from multiple members and multiple senators over the weeks. And I actually think it is possible that Aaron's Law in its current iteration, or more likely another iteration, could really be introduced. Whether it could be passed is another question. I mean, I think it's that the Department of Justice, I think, would not be cool with anything that would water down the CFAA at all. And I think that a lot of companies are very nervous because they worry about their own systems, and they worry about watering down any law that would be a legal protection against hacking that they could use. And even the companies that would never, you know, make that really lame contract argument, I don't know that they necessarily are excited about the idea of removing any sort of, you know, legal club that they might possibly have in their bag, right? So if we can get some companies in a position where they could see that it's advantageous and that it would be great, I think that that would be something that would be very useful. It's worth noting that over the past couple of years, there have been a number of proposals out there that have been endorsed by the Department of Justice and even by the administration that would actually make the penalties of the CFAA much harsher. It basically would eliminate any misdemeanor under the law. Pretty much everything would be a felony. And in certain circumstances, there would even be mandatory minimum sentences. And across the board, it would pretty much just jack up penalties all over the place, like the possible maximum sentences. And you know, I am hopeful that at the very least, this situation will keep something like that from passing. But you know, I think we'll have to see. I've been pretty amazed by the situation myself.
Okay, do you want to say any closing remarks?
Yeah, I just want to say thank everyone. I want to thank everyone for coming, and I would like you to join me in thanking our excellent speakers. And have a good night.
Yeah. I was wondering if the beginning kind of students for
Oh, thank you.
culture.